No puedo, yo hago lo que me dé la gana. ¿Quién dijo que no? Ey, que no puedo, yo hago lo que me dé.
Hi, everyone. Thank you for tuning in for our first Just Data event of 2026. I'm Vanessa Maturko, and this is Lost in Translation, the role of language in wrongful convictions. For those who have joined us before, welcome back. And for those who are new, our Just Data series is an occasional opportunity for us to showcase some of the social science research that's helping to advance the innocence movement, connect scholars across different disciplines, and hopefully inspire research into unanswered questions that, if addressed by you students and expert researchers out there, would help support our organization's day-to-day legal and policy advocacy and social work. Our agenda for today includes opening remarks by Christina Swarns, who will set the tone and context for the program. Former Innocence Project client Norberto Peets, along with one of his attorneys, Jane Pucher, will share some of his personal experience with wrongful conviction and the role that language played. You'll hear research from Jessica Arredondo Cruz and Dr. Sharese King about translation services and stigmatized dialects, respectively. This will be followed by a moderated conversation, and of course, then we'll open it up to your questions. So if there is anything that you're curious about, please write it in the Q&A box, and we'll do our best to get to you. Finally, Dr. Jamie Henderson will close out the program with some important announcements, so stay tuned for that. This webinar is going to be recorded and will be available on the Just Data webpage after the event. And now, to officially kick things off, I am pleased to introduce the Innocence Project's Executive Director, the one and only Christina Swarns.
Thank you so much, Vanessa, and welcome to everyone. I'm going to start by sharing two anecdotes as a way of anchoring today's conversation about the role of language in wrongful conviction. First, I once represented a man on death row in Pennsylvania. He was born and raised in Puerto Rico. I was his lawyer in the state post-conviction proceedings, which of course took place many years after he had been convicted of murder and condemned to death. When I met him for the first time in prison, it was immediately clear to me that Spanish was his primary language. Although he did speak some English, I was not confident that his comprehension was sufficient to proceed without an interpreter. So I hired an expert to evaluate his level of English comprehension. She found that his ability to understand English was at an elementary school level. However, the trial transcript showed that while there was an interpreter, she was only used intermittently during the capital trial and sentencing proceedings. And my client told us that he had been reluctant to admit his language limitation. He knew that it would further stigmatize him. But without an interpreter, he was not fully able to share the information about his life and his case that was necessary for a comprehensive investigation and preparation for a defense. He could not have made informed decisions about the exercise of his constitutional rights. It was, quite literally, the recipe for a wrongful conviction. The idea of going on trial for capital murder and being sentenced to death in a language you don't fully speak or understand feels like an episode of The Twilight Zone or Black Mirror. But my client's experience is all too common. The reality is that interpreters are not always available for those in need. And every public defender will tell you that requesting an interpreter often occasions long delays. Those delays cause unnecessarily extended detention, And spending time in jail can trigger a chain reaction of collateral consequences that increase the risk of an unjust outcome. Add to that the pervasive bias against those who are not fluent in English, and the odds of a wrongful conviction increase exponentially. In case you're wondering, I did raise a constitutional challenge to the absence of an interpreter. That claim was denied, although his death sentence was vacated on other grounds. The second example is one that many of us heard about in the news, the so-called lawyer dog case out of Louisiana. In 2017, the Louisiana Supreme Court ruled that the statement, quote, "Why don't you just give me a lawyer, dog? Because this is not what's up," close quotes, did not constitute a clear and unequivocal request for counsel. This, of course, is English. But in our country, there are expectations, biases, and hierarchies surrounding accents, dialects, and vernacular speech, which perpetuate unfairness in the criminal legal system. In the Louisiana case, that prejudice operated to deny someone their constitutional right to counsel, the key element to preventing a wrongful conviction. That's why today's conversation is so important. We need to understand the ways in which language can and does impact due process so that we can generate solutions and prevent unjust outcomes like wrongful convictions. So with that said, I am thrilled to introduce you all to my brilliant colleague, Jane Pucher, a senior staff attorney in the post-conviction litigation team at the Innocence Project.
Thank you so much, Christina. Hi to everybody. It is my privilege to be next to my former client and good friend, Norberto Peets, who was exonerated in May of 2023 for an attempted murder that he had nothing to do with that occurred in 1996. I'm going to give just a few moments of background about that case because it's important for understanding the role that language played. And then I have some questions for Norberto for everyone to listen to. Norberto was convicted of an attempted murder that happened in the Bronx under an elevated subway platform in the middle of the night. There was gunfire that was going off near the stairs of the elevated train, and some police officers happened to be driving through the area and heard the gunfire. They stopped, and they saw somebody running away at a far distance from them. They gave chase and exchanged gunfire with that person. That person, as he was running away, fell down, was on the ground for a few moments, eventually got up and ran away and disappeared and was never seen again. The location where he fell, a bloody bullet fragment was recovered, and that bloody bullet fragment was collected and something that was kept in police evidence. A week later, Norberto and his cousin and a friend of his were out for the evening. They got stopped by the police for something completely unrelated and held in detention. And because the police decided that he looked somewhat like the person who had been the gunman that week before, questioned him, put him in the lineup, and began a prosecution that would last 3 years before he actually got to trial and take away 26 years of his life. Norberto at the time spoke limited English. He grew up in the Dominican Republic and had lived in New York for several years. He spoke Spanish with his family in his home. And as he'll tell you, had quite a difficult time understanding what the police were asking of him, he was being charged with, why he was being stopped in the first place. And that began tremendous confusion that went on from there. Norberto, I want to start by asking about your trial, where you actually testified in your defense that you had nothing to do with this shooting whatsoever, that you weren't there that night, that you were actually home with your family. Can you talk about interacting with your attorney and the investigator on your case, how language played a role in understanding or not understanding what you were being charged with?
Oh, thank you for having me. So at that time, few things that I was acknowledged that happened that was unaware was when my lawyer it was asking me question, he asked me in English. So like 3 times he went to see me in the bullpen. He never been interpreted with him. So I have difficulty to talking to him about the situation that I would be in charge. At that time, I don't even know the suspect was shot. It was to me, it's appeared to me that I look like because I'm black, I'm a black from another country. It's appeared to me that I confused me with somebody else. That was my whole understanding at that time. And then I was in my mind thinking, oh, they're gonna figure it out it's not me, and I'm gonna walk away. So my lawyer never told me the right question to understand what was going on. And because for that situation, the English language took a lot of missing barriers that I could not be fully to able to explain to my lawyer at that time.
Yeah. And you mentioned something very important, which was that you didn't know when you were sitting there at Rikers Island for 3 years waiting to go for trial that the person who was the gunman who actually committed this crime had been shot himself. That had never been explained to you. And why was that significant? Why did that matter?
Okay, I spent almost 2 years in the island that I was blind about this case because my lawyer never told me that the real person that committed a crime, it was shot in the scene and gets away. One time I was working as a suicide watch in C95 with a Puerto Rican guy named Danny, and then we started to get close friends. And then he speaks Spanish and Puerto Rican, and Dominican, he was Puerto Rican, so we started talk about our life. And I told him that I was confused with somebody else, and that I was pulled over 1996, September or 206, and they said that I shot a cop. When I told Danny the situation, Danny asked me, "But I see you like 18 months in here. Do you have any paper that what really took place at the scene?" I said, "No." And Danny, for the first time, write me a letter, and then in English, and I give him the letter to my lawyer. And my lawyer, for the first time, give me some paperwork, and I was able to at least understand a little bit what happened. Danny took it with him and read it, and it started translated for me in Spanish. I put the paper number like that when I'm going back to my court date to me understand what was going on, to take a page and told the lawyer, listen, this is what I find out, and you never told me this. And he write a lot of notes in Spanish for the first time.
So it took another incarcerated individual who spoke more English or can write in English to sort of translate to your lawyer what you wanted to know and to get you information.
Yes, it
Yeah.
was. Yes.
And the reason, of course, that it was very significant that this person had been shot is that Norberto had not been shot. He had no injuries. He had never been shot in his life. And if this had ever been told to him, let alone if discovery had been given to you, paperwork from the police showing that this person had been shot, you could have brought that as a defense and you could have had your lawyer investigate that. And maybe even in those first couple days after you were arrested, explain this couldn't have been my client because my client wasn't shot. And am I correct that when you finally got police paperwork, it was still all in English? Nothing was translated into Spanish. Is that right?
Yes.
Yeah. Talk a little bit about trial. So you eventually went to trial and you testified as well as several members of your family. What was it like testifying, in Spanish using a translator? What do you remember about that?
I remember a few incidents that took place because at that time I understand a little bit more English that I could speak. So it was a time that I told him something in Spanish, and when he said it in English, it was not the same thing. So I don't know if he did it with malicious intention. I don't know what was the meaning for that. And that happens to me a few times. Also, that happened to me with my investigator.
Mm.
When investigator went to see me in the island, he writes a couple of stuff that I never told him that.
Mm-hmm.
And man, I was struggling there to talking to him because he don't be no interpreter with him.
Mm-hmm.
But that happened to me with interpreter when I was going to trial.
Mm-hmm.
Well, my first two times I went to the first trial and I had a breakdown my first one. And my last trial when I was found convicted, the same thing.
And I remember you told me that you felt like sometimes you would give a statement and what they would translate out was different than what you had said, or it didn't capture the full meaning of what you were saying.
Yes.
Yeah.
Yes. And I'm asking in Spanish, I say, yo, but I don't tell you that. You say something else.
Mm-hmm.
But they will not pay attention to that. I told him that 3 times, the interpreter in the courthouse.
And even the fact of language played a role in evidence pointing towards your innocence, because you learned later on that the person who was the gunman was yelling in English to the police officers. And you at the time were not speaking English predominantly, you spoke Spanish. So, what did you make of that fact?
I, wa- when the first time I just read, it was when they went to see the officer in 2009, 2020,
Yeah.
when they was telling that the suspect was yelling in the street, police shot me, police shot me. I don't even know that word, that thing happened. And to the Integrity Commission, went to see Officer Staten, I believe it was.
Right.
I don't even know that. So I was saying to Jane, because it was when the incident took place, it was two Spanish people got robbed for $20. Everything happened for $20. And those two Spanish people were supposed to be Dominican, but they was light skin. And when they identified the robbers, they say Moreno Americano. No, no, because it's something about Spanish people. You can be from Puerto Rico, you can be from Cuba. I know exactly when you speak that you're not from Santo Domingo because the accent. And I told Jen that the two guys that got robbed, it was Dominican. They was able to identify me. Leaving the town that I'm born in La Romana, because us we speak the AR Romana. So I told James that we gotta get Acosta and Reynoso, because Reynoso and Acosta, there was the two guy. It was almost in the friend of the kid that they robbed them. So I told James that all the time, and my lawyer never investigated that. They never investigated the conflict behind the $20. Everything was gone from there. So everything, living in the courthouse, that was directed to me as a Black American. And then my last name speaks because my grandfather for St. Kitts, one of the Virgin Island, and I have more problem because for that. And I believe, because I believe and sincere in my heart, the Pablo Brea, they don't bring the case against him because the name Pablo Brea sound too much Latin. My cousin Ivan Holges, it sound too much Latin. My name Norberto Peets, and I'm real dark skin, sounds like I showed to the Christian that I was Black America in one sense, only to get convicted. And that's what they did. Because there was a time that the DA asked Arroyo, the guy sitting in the bench right there, he looks Spanish to you? And Arroyo say, no, he looked black. But the DA knew that I was Dominican, that I don't even know English. And I'm sitting in there with interpreter, looking at Arroyo, stupid. You don't know that I got interpreter here? I don't even know. And no word in English. And that I believe that I took a lot of place to my conviction. The language barriers.
Yeah. And when your family who testified talked about that experience, do you think that they're, speaking primarily in Spanish and needing English interpreters, do you think that affected how they could testify? Because they were coming in to talk about how you were home with them. You had a very strong alibi defense, and yet you were convicted. Do you think that played a role?
I think played a role because living the mama speak good English, but she not born in this country. She know English because my great grandma, she came from St. Kitts, and that's the only language that my great grandma speak. At that time, my mom was growing. My great grandma started speak English to my mom. Mama started catching up because there was a lot of things that mama that was asking questions to mama in the courthouse that I believe in my the mama don't even understand what they would say to my mom. And there was a lot of confusion. My two brothers, they went to school at the time when I was going to trial. I believe they was on the age 17, something like that. Cholo was almost on the age. It was too much pressure to them. And they came in here when Cholo came in here when it was 9 years old, and Kendo it was like 8, and Haley was like 10. I was 18. So I never got a chance to go to school in here. So the little English that I started learning when I was working for New Sports Club, working in construction and stuff like that, listening to the TV, and I went to jail. I started to learn more English. But I believe that took place a lot with my family too. A lot of manipulation on that English
Absolutely.
barrier.
Well, I know there are going to be a lot of questions for you at the end. because people are going to want to hear more of your story. But I'm going to pass it now to Jessica Arredondo Cruz to speak about her research. Thank you.
Okay, thank you so much. Thank you, Innocence Project, for organizing this event and for having me here. My name is Jessica, and today we'll be presenting on language assistance and barriers in the courtroom. So, quote, during the trial, the interpreter makes errors which you do not catch because you do not speak the language of the foreign country. Your attorney does not object to the interpretation errors because she does not speak English and is unaware that errors were made. The jury returns a verdict of guilty. After the trial, you try to appeal your conviction on several grounds, including that the interpretation errors were prejudicial to your case. The appellate court refuses to reverse your conviction because your attorney did not object to interpretation errors at trial. And even if extrinsic evidence of the interpretation is allowed on appeal, you may not have access to bilingual transcripts of the trial if they exist, because not all court transcripts capture and preserve languages other than English. This is how legal scholar Deborah Hovland begins her 1993 article. Her words illustrate the risks and realities faced by some limited English proficient defendants in the United States, which I expand on today. Specifically, I use cases to demonstrate how language barriers and issues undermine justice and fairness during criminal proceedings and post-criminal convictions. In the US, where about 22% of the population speaks a language other than English, and where many federal and state court proceedings involve an individual with limited English proficiency, LEP individuals, like I mentioned, have a limited ability to read, write, speak, and understand the English language. Importantly, their English speaking skills are not enough to understand legal concepts such as their due process rights and require the assistance of language court interpreters. The number of LEP individuals involved in the criminal legal system is likely an underestimation, as there are more LEP individuals than available certified and qualified interpreters. So at the outset, this is access to a language interpreter is a barrier. So jumping to barriers during criminal proceedings, the Court Interpreters Act of 1978 established the right to assistance from a court interpreter for anyone who speaks only or primarily a language other than English. An important question is whether providing LEP defendants with language assistance is enough to protect their due process rights, or similar to the right to a defense attorney is the real issue, the right to effective assistance. To that question, the courts have recognized that a defendant's constitutional right to an interpreter means a competent interpreter, not necessarily a certified one. This decision is interesting given that research finds that certified interpreters outperform non-certified ones across several interpretation criteria, including their ability to deliver complete and accurate interpretation, which is required of interpreters in the United States. This means that using uncertified interpreters does not necessarily guarantee the interpretation they provide to LEP defendants is accurate and/or complete, which may undermine their ability to understand and participate in criminal proceedings. For example, in 2004, Juan Ramon Alfonso, a Spanish speaker, entered a guilty plea in Florida. For reasons that will soon become clear, Juan thought he entered a guilty plea to a misdemeanor and would be sentenced to probation. Really, he entered a plea to a felony and was sentenced to 15 years in prison. Juan appealed his felony conviction, claiming that the appointed uncertified interpreter at his plea hearing provided an inaccurate interpretation of the charge's potential sentence, among other things, which undermined his ability to understand the information and to make an informed decision. On appeal, an expert witness evaluated the interpretation provided to Juan using bilingual transcripts of the hearing. Here I provide excerpts from the expert witness's analyses to illustrate some of the types of interpretation errors that can be made. So at Juan's plea hearing, a court actor in English said, "Is this a first degree? 30 years in prison." So I thought there would be a plea offer. What was communicated to Juan in Spanish was nothing because the interpreter omitted some information. A second example, an English-speaking court actor said, "Judge, pursuant to negotiations, the prosecutor would be offering for in return for a plea of no contest and a withhold of adjudication, hopefully." What was communicated to Juan, but now translated in English by the expert witness is, "Your Honor, according to the businesses made with the state attorney's office, if giving of no, not to adjudicate you guilty." So here we can see that the information that was communicated to Juan was not accurate and was also missing very important details about the plea offer. So omissions and inaccurate interpretation limit the amount and quality of information LAP defendants receive, which can impact their outcomes, such as thinking that you will receive probation, not prison. The courts overturned Juan's conviction, and now in Florida, courts are required to appoint certified interpreters. Victor Ponce versus State of Indiana in 2014 illustrates similar but different errors that are equally important. In 1999, Victor Ponce, a Spanish speaker, entered a guilty plea. Similar to Juan, at his plea hearing, Ponce was appointed the assistance of an uncertified interpreter. Years later, Ponce claimed that his plea was not made knowingly and intelligently, and cited interpretation and translation errors in the way that the rights were communicated to him. So at the plea hearing, the plea rights that were communicated to Ponce were, one, communicated at the plea hearing, and two, they were communicated via a tender of plea form, meaning that errors may have occurred at a different time, place, and by a different person. On appeal, the courts first determined whether errors were made in the communication of the plea rights to Ponce at his hearing. There was a bilingual transcript available of the hearing, which allowed an expert witness to compare what was said by court actors and what was communicated to the defendant. And they determined or found that the rights communicated to Ponce were inaccurate. However, unlike the plea hearing, there was no record of what was communicated to Ponce via the two plea forms that he signed in English. Ultimately, the courts reversed Ponce's conviction due to the interpretation errors made at his plea hearing. However, it is believed that without a bilingual transcript, courts may not accept and hear LAP defendants' appeal based on interpretation errors. Omissions and faulty interpretation are some reason LAP defendants appeal their conviction. Scholars argue that courts, and I quote, "are so heavily balanced in favor of upholding the trial court's decision that only the most egregious sets of facts are likely to prevail," end quote. They are also likely to prevail because a bilingual transcript was available. However, as I mentioned earlier in this talk, not all court transcripts preserve languages other than English, and not all LAP defendants are aware that bilingual transcripts exist, assuming that one exists. The cases I present here illustrate how language-related errors contribute to miscarriages of justice for presumably guilty LAP individuals. However, language-related barriers and errors may too contribute to wrongful convictions and may add to the many barriers individuals wrongly convicted face on the path to exoneration. For example, Angel Gonzalez was wrongly convicted in 1995 and exonerated in 2015, and a quote from an article about his case, quote, "The day following the vacating of his conviction, Gonzalez returned to the court to fight the property damage conviction on the grounds that he had been wrongly imprisoned in the first place and that he had pled guilty to damaging the sink without an interpreter present." So here, Angel Gonzalez did not have the assistance of an interpreter at his plea hearing, which may have contributed to a wrongful conviction. A different example is of the barriers faced, is the case of Fernando Almanza, who was wrongly convicted in 2013 and exonerated in 2024, where Fernando Almanza filled out legal documents, presumably while incarcerated and with the assistance of a bilingual inmate. So here we see that some LEP individuals who are wrongly convicted require the assistance to fill out forms that will initiate the exoneration process or appeal with the assistance of bilingual persons who are not necessarily certified or trained to translate and interpret information. So to summarize, partially or faulty interpretation may contribute to miscarriages of justice. Convictions are rarely overturned on grounds of language errors, and there are known and unknown barriers to exoneration from filling out documents that are only written in English and to many more that we don't know. And the barriers that are present here are almost like the tip of the iceberg. There are so many questions and issues that we don't know, and that social science research should continue to examine. And, yep, thank you.
Thank you so much, Jessica. Now I would like to introduce Dr. Sharese King. Dr. King is an associate professor of linguistics at the University of Chicago. She received her PhD from Stanford University in 2018. Her research explores how African American identity is constructed through language and the implications for racialized voices within the US judicial system. Dr. King has co-authored an editorial in the Los Angeles Times and has published in journals such as Language, Race, and Justice and Nature. Take it away, Dr. King.
Thank you so much for that introduction, and thank you all for organizing this session today. I'm really honored to be able to contribute some of the research that I'm aware of and that I am currently conducting. So today I want to talk a little bit about what it means to be a sociolinguist or a linguist, because I don't want to assume that everyone is familiar with it, and jump to talking a bit about what linguistic bias is and how we see it manifest, particularly zooming in on the Zimmerman trial and Rachel Jantel as the prosecution's witness in that case, and then just end with some sort of current projects and future directions that I hope other social scientists might build on. Okay, so linguistics is the scientific study of language and its structure, and sociolinguistics is interested in sort of this relationship between language and society. Now, we as linguists know that voices can carry a range of social information, including where a person is from, their age, the gender, race, ethnicity, amongst other kinds of social cues, without a speaker ever having to explicitly say that they belong to any of these categories. And so I am interested in the question of how listeners map particular social characteristics to a speaker, or which features they're using to draw inferences about who a person is. We know that differences in speech need not to denote deficiency, but these differences are often used to reinforce kinds of social hierarchies, including race, between groups of people. Now, linguistic anthropologist Rosina Lippi-Green has once stated that language-based discrimination is the last acceptable prejudice. And what does she mean by that? Well, she's speaking to the fact that it's the last frontier on which we can judge a person with impunity. And people don't tend to view having negative attitudes or assumptions about languages and dialects as potentially harmful. But as I hope to illustrate to you today, they really can be across a range of sites. Now, negative opinions about language are not based in linguistic science, and we need to explore how language becomes a site, again, for discriminating against others. Specific languages can be discriminated against, as we've been hearing about so far, speaking to the context of Spanish. But there are other kinds of linguistic discrimination that have to do with stigmatized dialects in the United States. And so that can include things like Southern English, Chicano English, and African American English, which is what I study the most. So my examples will draw mainly from that particular dialect. Now, linguists have sought to correct prejudice against specific language varieties through scientific analysis that objectively demonstrates that these stigmatized varieties are rule governed with their own sets of grammars or linguistic norms that are understood amongst the speakers of those particular varieties. And so, even though the patterns in these languages are consistent and systematic, the perception of unrecognizable terms or patterns can often generate stigma. Further, it can be difficult for people to divorce language from, again, social hierarchy, as understanding whose speech is regarded as more acceptable is a means of understanding which groups tend to be more valued or reap more benefits in the society, versus those whose speech is regarded as unacceptable and incorrect and face harmful consequences across various sectors of the society. So, as I mentioned before, my work tends to focus a lot on African American speech, and I have a general definition here from one of the leading scholars in our field, John Baugh, which states that English, it is the English used by a majority of U.S. citizens of Black African background. Of course, I'd like to add some caveats to that. Again, it's a rule-governed dialect, but it's not necessarily exclusively used by African Americans. There are others who have grown up in these communities who may know the language. And not all African Americans would consider themselves speakers of the dialect. So, as I stated before, I'm interested in what the social and political consequences of speaking a stigmatized dialect are and how we address such challenges. And so, some examples of how this shows up or manifests across a range of dialects and language includes in the context of housing, employment, healthcare, and the courtroom, which has been the courtroom has been the kind of site that I've been looking at most often. So you heard this example in the introduction with the lawyer dog being ambiguous, right? And so the prosecution made the argument that, well, when he requested for a lawyer, saying lawyer dog was ambiguous with perhaps a dog that is a lawyer. That confuses me as well. But ultimately, this is a person who did not receive legal counsel when they requested it. Another example that I don't have a link to here on the screen, but I'd like to mention is a 1999 case with Clifford versus Kentucky, where a white officer testified to hearing a Black man's voice making a drug sale, despite not seeing the interaction visually. And so Charles Clifford was the only Black man in the room and therefore determined to be the drug seller. And so in this example, right, perception of a Black voice based on an ear witness testimony versus an eyewitness testimony was used to successfully obtain and uphold a conviction. Okay, so this is just one particular example. But I'd like to also think about how the production of racialized dialects by a particular witness can affect the outcomes of cases. And so for this, I turned to a paper that I co-authored with my advisor at the time, John Rickford, and we looked at the speech of Rachel Jantel in the context of the Zimmerman trial. So she was 19 at the time of testimony, born and raised in Miami, and a star witness and central to the prosecution. She was the last person to speak to Trayvon Martin before he was killed by George Zimmerman on a walk home. And despite being an auditory witness, her testimony was largely dismissed by jurors for reasons that we argue had to do with not the testimony itself, but more so the way that she told the testimony, right? And so throughout this paper, we sort of discuss how dialects can be found guilty before a verdict is ever reached in a particular case. So this is an excerpt from day one of Rachel Jantel's testimony that I want to play. And in this excerpt, the prosecutor is asking her to recall the events up until the call hung up, okay? So I have parts that are highlighted in red that represent aspects of the dialect African American English that I'll talk a little bit more about after I play the clip for you.
He said he from the radio. He told me here for that. He did that fiance house at the area where his dad fiance buy his daddy fiance house. But I think, you better keep running. He said, he lost them.
Stop a second. This lady's gotta take everything down, so you make sure you're, okay. So after he said he lost it, what happened then?
He said he buy the area that his daddy house is. His daddy fiance house is. And I told him he running. He said, you're just going faster. I'm like, oh, nah, I ain't gonna forget to still breathe that hard. So I understand why.
What happened after that?
Then second later, I turned around and said, oh shit. Second later? A couple seconds later, turned around and said, oh shit.
You say the words, oh shit, or how language. Who said that?
Trayvon.
He said it to you?
Yes.
Okay. And after he used our language and said, oh shit, what happened then?
Nigga by me.
I'm sorry.
The nigga by me.
So it's clear from my perspective that, okay, Rachel Jeantel is a speaker of African American English, and her speech patterns align with some of what prior research has established since the 60s on the patterns of the dialect, including what we would call copula absence. So that is the absence of the verb be. So is and are might be deleted. You might have something like possessive absence, so saying daddy house instead of daddy's house. Those are just a couple examples of features that show up within this particular testimony. And it raises larger questions about how well understood speakers of this variety are believed, okay? So the issue of misunderstanding often intersects with evaluations about the speaker and their credibility. And so as evidenced by this juror from the George Zimmerman trial who claimed that Jeantel was not only hard to understand, she also had something to say about her credibility in the end. And so I'll play that clip for you now. Oh, sorry.
Did you find it hard at times to understand what she was saying?
A lot of the times. Because a lot of the times she was using phrases I have never heard before and what they meant.
When she used the phrase creepy ass cracker, what did you think of that?
I thought it was probably the truth. I think Trayvon probably said that.
And did you see that as a negative statement or a racial statement, as the defense suggested?
I don't think it's really racial. I think it's just everyday life. The type of life that they live and how they're living in the environment that they're living in.
So you didn't find her credible as a witness?
No.
So my co-author and I watched this clip and we thought to ourselves, okay, so we're having already some misunderstanding with some of the phrases that are coming up, right? So that's an intelligibility issue. But we also are finding that this kind of conversation is being had alongside questions of credibility. And so I want to put these comments in a broader context of work in the literature, emphasizing how dialect or language prejudice potentially affects case outcomes. And so we know from prior work that accented speech can be judged as less comprehensible, and that just doesn't go for dialects, that goes for languages, right? Even someone who is a second language learner of English, right? Non-standard accents are judged as more guilty, and this has been found not just in the United States context, but also in the UK context. Accident English may be rated as less credible. So if you give people random facts, trivia facts, and you give it to them across different kinds of dialects, they're more across different kinds of accented Englishes, right? They're more likely to disbelieve this random trivia fact if it comes from an accented voice. There have been eyewitness testimonies that have been perceived less favorably if the witness testified with an accent. And often we see a lot of mistranscriptions, as has been talked about in the last case, and misparaphrasing by court transcribers. And so this isn't an issue that just exists in how the witness is talking. This is also in how the court transcriber is able to represent their speech in court documents, right? Which go on to be used in different ways, especially if a person decides to appeal a case. So I want to talk a little bit more about some of those examples. Here is an example from particularly an inmate call that my co-author and I were asked to transcribe, and it happened in the context of East Palo Alto. And so the person said something like, the person who was accused said, "I'm fitna be admitted." Now, you might have heard fitna before. It also can stand in for finna, okay? I'll explain a little bit more about what that means. It was transcribed as unfit to be admitted, which is different from fitna, okay? Why is this different? Well, when you're saying a word like finna or fitna, you are essentially saying I'm fixing to be admitted. It comes from the Southern sort of colloquialism in which it marks an imminent action is about to occur. But the way that it's transcribed as unfit to be admitted instead gives a different kind of meaning that frames it as the person is consenting, right, to being admitted. And so this is just one example in which we see mistranscriptions affecting the facts of the case, right, representing aspects of the case. Here's another one, and this actually is not from African American English, but an example from a Jamaican Creole speaker. And I think it's a really important one because the speaker says, "Me drop a ground and then me start run." Also, I apologize as I'm not a speaker of this particular variety, but this is what was spoken by the person who is in interrogation. Here's what it was transcribed as. "I drop the gun and then I run." Okay, why is this a problem? It's a problem because it should have been transcribed as "I fell to the ground and then I started to run." Luckily, we had a transcriber who is a Jamaican Creole English speaker who corrected the transcript to the following. And if it weren't for her catching the error, right, the transcription would have shown an attribution of the responsibility of having a weapon to the speaker that they didn't actually state, right, in their recounting of the events. So again, this is just yet another example of how intelligibility can really affect transcription and the broader harms that linguistic differences can pose in the context of different kinds of legal interactions. So I'll just take my final minute to speak to some of the various projects I have going on, as well as ones that I've published on. I've linked that for you on the left. I'm currently in the process of designing experiments and running experiments to test how listeners judge speakers' characters based on their accents and whether the speaker is a defendant, a witness, or a lawyer, right? I don't want to just assume that this isn't just a problem for the defendants, but this is a problem for a range of actors who speak these dialects within the context of the courtroom. I'm also a consultant on legal cases, especially in the context of California. So I investigate racial justice claims made in capital cases there as well. I don't know if we're familiar with the Racial Justice Act. You can ask me more questions about that in the Q&A. This is an area that needs a lot more research. So those of us who are academics and social scientists interested in doing that kind of work, I really implore you to look further into the impact of sociolinguistic justice. Thank you.
Thank you so much. That was a fantastic presentation. So we have some time for questions that we've thought through as a group, and then we're going to open it up to questions from the audience. I think, Dr. King, I just want to start with you since you were just last speaking. I'm curious, from your view, what is needed to better arm interpreters and people who are working in courthouses that have many different languages, many dialects being spoken? What can courts do to better bridge this gap?
Yeah, no, thank you for that great question. I think there are multiple solutions at different stages and different aspects of a case, right? For one, if you're going to be doing interrogations and having someone sort of do a transcript of what was said, I think you want to make sure that you get someone who, if they're not a linguist, is familiar with the dialect being spoken so that we can make sure we have accurate representations of what people were saying or what they were told, right? So that's one aspect. Some people have sort of argued for the presence of interpreters, even for speakers who do speak English, but use a heavily stigmatized dialect. And so that one I think is a bit more controversial because some people feel as if it might other them in a particular kind of way, but still something to consider. And then I also think just making sure we have accurate representations of these documents going throughout, appeals and things like that is going to be really important. So there are a lot of different things that we can think about, but those are just a few that come to the top of my mind right now.
And Ms. Cruz, a little bit of the same question for you because you're showing such powerful transcription errors in your presentation. In the cases that you've looked at, has the issue been just the training of the person who did the transcription not being well done, being rushed during the court process and making mistakes? What do you think are the source of the errors that you've seen?
I'm sorry, this is for me, right?
That's right. I apologize.
Okay,
Yes.
sorry. I think with something that stays constant with the cases that I've presented today is that the interpreter was not certified. They may have been proficient in Spanish and English, but they weren't certified to provide an interpretation. And I think that's one of the biggest issues. And the interpretation literature researchers have called for increasing the qualification requirements for interpreters so that they can have and receive more training and education to then deliver more accurate and complete interpretation. Whether time plays an issue, I mean, I'm sure it does if court proceedings are rushed and if many different people are speaking, that could also impact what the interpreter hears and then is able to deliver to the defendant.
Thank you so much for that. Norberto, I'm curious, when you were using or working with a translator during your trial, did you get to meet that person before the trial started, or did they start translating kind of as you're on the stand testifying? If you remember.
I don't recall if I ever meet him, like if he went to the bullpen and talking to me about anything. I think that I meet him when I was going to the court, inside the courthouse. I mean, inside the courtroom. I don't think that I meet him in another place.
And what do you remember, if you remember any specifics, him translating incorrectly or any moments where you thought, gosh, that was really wrong. You really got that wrong.
It was a few times that I did that. I would acknowledge that because I was like, wait a minute, but I don't say that. He says something else. But in the meantime, I was like, okay, but in my whole trial, I was like, okay, I'm innocent. They're not going to do anything to me. Even though he's saying whatever he's saying, I was not thinking about I would have been convicted. But it was a few times that I was like, I don't say that. Because I was paying attention to him because when I say anything in Spanish, I want to make sure they say the same thing that I'm saying. Because I understand more English that I speak. So I'm like, okay, but I don't say that. Why is saying that? But I don't got a chance to address him in another place and ask him question. Why you say things that I never say? And I was thinking about that, but and that in my mind, I was not thinking I was going to be such a big deal behind that. That was the thing that plays out in my brain at that time, but I think it plays out a lot.
Something that came to mind for me, I was a public defender for many years before I came to the Innocence Project and worked a lot with interpreters. And it always struck me how fast it was that an interpreter would meet someone and immediately start interpreting, not getting to interview them or learn their patterns of speech. And I'm curious for either of you, Dr. King or Ms. Cruz, have you seen any research or done any research around how time and getting to know someone might impact the accuracy of interpretation, or matching up people who come from the same country of origin, that language and word choice is more similar? Have either of you seen anything around that?
Do you want to go first? Yeah.
Sure. So I do know that in the United States, certified interpreters have strict guidelines and requirements. So at least certified and professionally qualified interpreters are not advocates for defendants, so they can only say what is being said. They cannot add or remove. They can also, if there are issues, they have to bring it up to court actors before they can somewhat be more of an active participant. I do know that in research by Professor Sandra Hill has looked at some issues related to preparation, and she calls for this need for interpreters and translators to receive document and information beforehand to then prepare to provide a more accurate interpretation. Whether there's time for that to happen is a question. Mhm.
Yeah, so I don't know that there's any research, at least from the linguistic side, that looks at sort of developing a relationship with people before you sort of engage in this translation. I will say on the side of court transcription, I've had the opportunity to give a talk about some of this research to court transcribers in the context of Minnesota for continuing education. And one of the things that came up for me, because I learned as much from them as they did from me, is that they um they are aware sometimes of these linguistic differences, but they don't have a way to represent it in the file. They take a lot of shorthand, right? And so there's a sense in which it's a logistical issue as well. They need to be able to have more sort of training around how to represent different kinds of dialectal or linguistic, just more broadly, variation. And so that's an issue. And even for people, Taylor Jones and colleagues have an article in Language that was published, I want to say maybe in 2018, sometime around then, in which they look at giving examples to actual court transcribers, and even the ones who say they have familiarity with the dialect still don't do well when you give them things on the spot in that kind of way. And so, yeah, it's something that is a standing issue that we don't yet have a solution to. But I do love the idea of developing more of a rapport between those people who you're translating for and the translators, essentially.
Thank you so much for that. And of course, this means no disrespect to the translators who are working in courts every day. Seems like an impossibly hard job and just not enough resources and time to really process what's going on accurately each time. I guess on that note, a question for both of you again. What do you see as the risks and benefits of using digital or AI translation in the absence of live translation during either court proceedings or interrogations?
So I'll jump in just to say I think it could be okay as a backup, but it shouldn't be the main transcript we rely on. I've done some research with some colleagues out of Stanford University that was just published in Nature to show that AI language models sort of discriminate against speakers of African American English. And so I'd be worried about relying on that kind of technology to transcribe those kinds of interactions, and would say it might be a good first pass, but we should always keep access to the original sound files in order to be able to get a human to go through and appropriately represent it.
Yeah, I agree with Dr. King. I imagine also that AI cannot capture some of the non-linguistic cues that again can only be captured by humans. Yeah.
Thank you so much. Another question that we had for both of you is whether you're aware of research examining issues around other languages, not Spanish, not African American English, that you might speak to briefly.
Yes, I'll jump in to say there has been some work done around American Sign Language as well. So it doesn't just happen with spoken modalities, it also happens with signing, such that people don't get the appropriate access to people who sign, right? And who sign in their particular dialect. But they also find that they may sort of what's the word I'm looking for? Based on how the extent to which one is deaf, because there are still some people who are deaf but also speak, might sort of limit the amount of access you get to a particular translator or not. And so, yeah, there are some intricacies that come with signed experiences as well.
I've also read studies where it's looking at limited English proficient individuals who speak different languages, but also looking at individuals who are in English as a second language. So their English is more proficient than limited English proficient individuals. Studies by Professor Anita Palenko, who have found that even individuals whose language is more proficient than limited English proficient individuals have a poor understanding of Miranda rights. So even then, they struggle to understand legal concepts.
If I can jump in, I'm sorry, really quickly. I just remembered something else. Diane Eads is a researcher who I would encourage people to check out her work, who looks at this across other kinds of dialects. So like other kinds of indigenous languages and contexts. I know I gave the example from Jamaican Creole English. And so, yes, there are other dialects as well to look at with respect to those as well.
Fantastic. Thank you. And I think on that note, before we transition to some questions from the audience, Norberto, you have two brilliant scholars and researchers here and probably many more on the chat listening in. Are there things that you recommend them to research more regarding language and how it's used in the criminal justice system and how we think about the barriers that people face who aren't speaking English if we're in an American courtroom?
Of course. I gotta say that those guys, let's say for example, if you got arrested and you don't even know English, and the same thing that happened to me, it's really uncomfortable when you had like somebody like interpreting it's gonna be against you for the beginning of the time. So I wish that they could create something or try to help somebody with a barrier about communication, because it's really important, especially right now, the time that we're in right now.
Yeah.
The other stuff that's going on right now in the country.
Yeah.
And I wish that you can do something about it, because there's a lot of injustice right now against a lot of people because the English barriers. There's a lot of things going on. It's been going on for a long time. Been going on when the time that I got arrested, but now it's getting worse.
A lot to do, right?
A lot to do.
Yeah.
Yes.
Well, thank you so much for that. And thank you to everyone listening and having such great ideas. We're going to go to a couple questions that came in from the audience. And this is one that came up early and I think is a great one. In what ways are interpreters held accountable for their errors in interpreting that lead to wrongful convictions?
Yeah, that's an important question. So from my understanding, certified interpreters can, because they're required to deliver complete and accurate interpretations, if they don't, they can risk losing their certification license. What that looks like in practice, I'm not too sure. I haven't read many studies and like research on what happens when an interpreter, the case of Juan, where there was an uncertified interpreter who misinterpreted. That I'm not too sure what the process looks like for them. But very good question.
Dr. King, anything to add? Sorry.
I would also just second, I don't know how that looks like in practice. And I don't know the extent to which they should be held accountable for a sometimes faulty system, right? I think there is a sense in which I don't want to just blame the interpreters. Sometimes they are the problems, but also sometimes the problem is that they are not getting extensive enough education through their certification, right? So yeah, I think it's sort of a multifold problem. Yeah.
Right. Or being put in a system that isn't giving them resources to be able to do their job well, that they might actually be trained for.
Yes, and
please.
just to add to that, like language is so complex with
Mhm.
one that when we add more or different dialects, yeah, I completely agree.
I mean, I'm a linguist that gets asked to transcribe things, and I transcribe them very in a lot of detail, right? But I have to play it back multiple times in order to get the correct transcript. That's something that on the fly you don't have access to, right? And so I think that just raises larger questions about sort of who gets to go back and correct or, make sure that you got it right the first time. It's hard.
Yep.
Great. Here's a question that might be more to you, Dr. King, although I think anyone can chime in. One person in the audience said, I understand that at times the jury is at the mercy of the translator and must take the translation for what is transcribed. However, in the case of Rachel's testimony, is it incumbent on the jurors to make sure they understand the context of her testimony?
Yeah, I think that so one of the things that I didn't get to show because of time is we have access to parts in the transcript where you can see jurors speaking out of turn during the middle of trial, saying, trying to clarify or repeat what was said. And that just illustrated to us, okay, they are trying to make an effort to understand what is being said in real time as well. And they were scolded by the judge to say, okay, you can't talk out of turn. You have to raise your hand when you don't understand something. But like, if you don't understand all of it, like what then is the sort of solution? A second thing I want to mention is that when you go to deliberate, you don't get an entire transcript. People get to request a playback of a particular part of the trial, but they have to go based on what's in their memory. And so you want to make sure that what's in their memory are the correct facts. And so part of it is going to be about how attorneys prepare their witnesses, and just making sure maybe even if you need an expert witness to come in and talk about a particular language or dialect, that you have the resources ready for the jury to be able to have a full scope of the picture.
Yep. Great. Jessica, a question for you. You had mentioned, I think, at the end of your presentation that there were some future research questions that you wanted to study. Wondering if you might be willing to tell us about them.
Yep. I'm working with my mentor, Allison Redlick, on analyzing or doing a content analyses of tender plea forms, such as the one that Ponce signed, and looking at whether there are any differences between what defendants receive in a Spanish language form versus an English language form. Again, just to see if there are like any errors or omissions and the readability too. But I would hope to do a bit more research on like the barriers to exoneration and what that looks like in the post-conviction.
Great. Thank you so much. Dr. King, is there any equivalent to certified court interpreters for different dialects, such as African American English?
Not that I'm aware of, actually. And so that, again, it's just another instantiation of the problem is that we don't have that, as well as even for some of the people, like I said, who claim to be familiar with or have enough knowledge of it, they still didn't do well on some of the experimental kinds of circumstances they were given to like transcribe African American English on the spot. And I don't have examples of those right now, but you can go to some of the papers that I've published, and we have that where they still are like okay, but not at the, the rate of, 80 or 90% you need to get certification, right? And so I think it's something that we need, but I'm not quite sure where to start yet. I know that there needs to be like more maybe trainings from linguists themselves, but it every, I believe, state has their own kind of system. And so there would be a lot of adjustments to figuring out how to make these things work across states.
And since you're unmuted, I think it is important for our audience to hear a little bit more about the Racial Justice Act and particularly about the work that you're doing with
Yeah, definitely. So the Racial Justice Act was legislation that was passed, I believe, first in like 2020, and then new iterations of it have been updated by Gavin Newsom and his team. And basically, the idea of this act is to say that there cannot be evidence of racist language in a trial, right? Whether that be between policemen, whether that be from a judge or attorneys, right? You cannot have evidence of such. And so what we're seeing is a lot of people doing post-conviction appeals on the grounds of this legislation to say, hey, these moments happened at trial, or these moments happened, during sentencing that really impacted not just whether or not a person was sentenced as guilty or innocent, but also the heaviness with which they were given the death penalty versus another kind of punishment, right? And so pretty much this is like the first kind of legislation of its kind in the country to really go ahead and address racist language in the context of the courtroom. And so a lot of my research has been going back to some of these former cases, especially where people have been exonerated, and looking at, okay, what are the tools used in order to create sort of racist caricatures of people, as well as were there misunderstandings based on the kind of speaker the defendant or a witness was. And so that's a lot of the work and research that I've been doing alongside Sam Jacobs, who is a former attorney turned academic at UC Berkeley, as well as University of California in San Francisco. So
thank you. A question that came in for you, Norberto, was whether you during your time serving 26 years for something you didn't do, did you meet other people that you came, without obviously naming them, but that you came to understand, suffer through similar things to you, with not being able to understand conversations with their lawyers, not understanding the discovery that was given to them, and how pervasive do you think this is from your firsthand experience?
Oh yeah, I miss a lot of people, a lot of stories over there. I miss people that it was a guy from Brooklyn. He told me a story that when he got arrested, the police say something to him, man. I don't know where they put a gun in his package, and he say something in Spanish. Oh, esa no la pistola, esa no es mi pistola. And the police, I don't know if the police say, oh, that's your gun. I met so many stories because people talk about the cases over there all the time. And sometimes I feel like, okay, this guy told me the truth, but sometimes I believe it because I was saying the truth. Who am I to say they're not telling me the truth? There's so many people in there that I missed one Mexican dude one time that was arrested. I met him in, I think was in Fishkill. And he was telling me something that I totally believed that he was saying the truth to me because he told me, yo no hice nada de esto. The only reason I'm in jail because they asked me question in English and I say sí, and I put myself into that. And there's a lot of people with the same story over there. For the last 26 years that I spent over there, I met a lot of people, a lot of strange story about the English barriers that we have over there when we got arrested. Living inside jail.
Yeah.
A lot of things that happens. When I went to Attica, there was a time that they put me, I was so nervous, they say something to me, put their hands in the wall, and I don't even understand that because at the time I was in shock. This guy almost killed me. This guy almost beat me on the death. They don't beat me up, but they was grabbing my legs, my probably part and stuff like that because I made a mistake. I could not understand what they were saying to me that quick. And that plays a lot in 1 second. That's a lot of missing understanding about the language and living inside in there.
Yeah.
A lot. It's in and out.
And everywhere.
Yes. Yep.
Thank you for sharing that. We had a comment question from an attendee named Katie who said that she wanted to mention that in addition to language and dialect issues, paralinguistic elements that can't easily be captured in a written transcript can affect outcomes, such as a defendant saying, I'm sorry during an allocution, but the I'm sorry is tears, for example, and just so many ways that having the record that becomes the basis for an appeal or post-conviction relief like we do at the Innocence Project often doesn't capture what actually happened in the courtroom. I think a final question before we turn it back to Jamie, or turn it to Jamie, would be to focus on how do we measure the disadvantage that language barriers create in the legal system. Dr. King, you said that barriers can make people appear less credible, can potentially subject defendants to being found guilty more easily. But is there a consistent form of measurement to actually understand how pervasive this problem is?
Not currently. I think that what we're trying to do is develop instruments to like test the various ways in which that these kinds of linguistic discriminations can show up. And so there isn't a single method right now. I think that is something that I would love to see larger projects across institutions, right, doing, is trying to develop methods to say, for example, of the people who were exonerated, how many of them had this kind of disadvantage in terms of like speaking a different language, or how many of the people who were exonerated had these kinds of constructions used to racialize them, said to them by attorneys in the context of the courtroom in such a way that made people believe they were a thug or whatever kind of other stereotype they use, right? So that's something I would love to see on a broader scale, but you have to get access to those kinds of transcripts on a larger scale and a bigger team to develop those kinds of data, statistics, I should say, yeah.
Yep, I second Dr. King. I think, well, one, getting access to transcripts if the courts are preserving languages other than English is difficult, but hopefully in the future there's better metrics.
Well, thanks to you both for being a huge part of what that hopefully brighter future looks like. With that, I'm going to turn it to Dr. Jamie Henderson, who's the director of our Data Science and Research Program. Thanks, Jamie.
Thank you, Jane, and thank you to our speakers for a really illuminating conversation. Just want to take a few moments to go over a few things with you and then share a really exciting research opportunity with all of you as well. Lots of questions have been posed in the chat about getting copies of the links or the QR codes rather that Dr. King shared. No worries, this webinar has been recorded and it will be distributed. There will be a link distributed to everyone. Once this webinar is finished, it's going to be on our very new Just Data webpage, so stop by and check that out. Another thing that we would like to call attention to that's on our new webpage that's very important is a document called a call to action. And if you are a researcher and you're looking for a way to get involved, there are a lot of research questions here that we as practitioners have identified that we need answered, whether that be for litigation purposes, supporting people who are coming home, or advocating for policies. And so stop by and check out those research questions, or conversely, if you are a researcher who has investigated some of these questions and you have some evidence that you would like to share with us, please reach out. Let's set up a time to chat. And if there are other practitioners out there that have other innocence-related questions, you can share those with us as well. It's a living document. We update it regularly. If you are wanting to do research that involves folks who have been wrongfully convicted and or people who work at Innocence Network organizations, you want to submit your proposal to the Innocence Network Research Review Committee. It's a group of folks who have research experience like myself, in addition to folks with lived expertise who look over proposals and determine whether or not it should advance within the innocence community. And lastly here, if you want to contact us about the research document, if you have additional questions, you've got some ideas for future Just Data webinars, email us, the Data Science and Research team, at science@innocenceproject.org. And now I would like to share with you a really incredible, I think it's extraordinary, honestly. This is probably the most extraordinary research project of which I'm aware. Our colleagues at Life After Justice are conducting a nationwide survey of wrongfully convicted people and their loved ones to help understand the long-term impacts of wrongful conviction on physical, mental, relational, and financial health. The research is being led by a team of wrongfully convicted people and is the first that is for wrongfully convicted people and by wrongfully convicted people. This is truly, truly incredible. They currently have 107 completed surveys, but they need to reach 350, right? We need a certain sample size so that we can generate really rigorous evidence. If you are a wrongly convicted person or a loved one, scan this QR code to sign up for the survey. You will receive a personalized link to complete the survey via email and text, and you will receive $50 of compensation. Contact info@lifeafterjustice.org, and we'll put that in the chat if you have any questions. And with all of that, it brings our presentation to you to a conclusion. I just want to thank all of our speakers, Norberto, Jane, Sharese, and Jessica. And thanks to all of our colleagues who made today's presentation webinar possible in development and comms and the extraordinary data science and research team. Thanks, everybody, and have a wonderful day.
Thank you.